Welcome everybody to today's presentation. My name is Paula Price and I'm with the People's Law School, and today's webinar is called People, Parking and Pets, Strata Living in British Columbia. And we're delighted to be joined by our guests, Oscar Miklos from Refresh Law and Kate Campbell from the CRT. And I'll introduce them in a few minutes. This webinar is for individuals who have questions about strata living. So if that's you, you are in the right place. And our speakers will answer questions about everyday legal issues that relate to living in a strata in British Columbia. And we're going to introduce our speakers in a moment, but first I just wanted to acknowledge that the land on which the People's Team is gathered is the unceded territory of the Coast Salish peoples, and that includes the territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. We'd also like to acknowledge our funders, with financial support of the Department of Justice, Government of Canada, as well as the Law Foundation of British Columbia, whose support has made today's webinar possible. And with that, we'd like to introduce our guest speakers. So first we have Kate Campbell. And Kate is the Vice Chair, Strata Societies and Cooperative Associations at the Civil Resolution Tribunal. And for anybody who is learning about the CRT for the first time, it is an online dispute resolution forum, and it has received international recognition for its increasing access to justice. And Kate will be telling us a lot more about that. She has been in the position of vice chair for the last year and a half. And before that, she was the first full-time tribunal member. And we talked a bit yesterday about the number of cases that have gone through relating to stratas, and the number is somewhere close to about 4,000 cases. Not all of those go all the way through to the end. There are about 1,200 reported decisions, but this is an area that, that they see a lot of claims. So it'll be really great to hear Kate's perspective. Kate, welcome. We are so delighted to have you here today.
Thanks, I'm happy to be here.
Fabulous, thank you so much. And we have Oscar Miklos, and Oscar is a lawyer, and he is the founder of Refresh Law. And his practice is in the areas of strata corporations, strata homeowners, residential landlords, and property owners across British Columbia. And I noticed a bit of a theme today when I was on his website, as his firm is an innovative, technologically driven practice delivering practical and cost-effective legal solutions. And I note that his firm provides services not only in English, but also in Punjabi, Hindi, French, Spanish, and Hungarian. And I loved this quote that was on Oscar's front homepage. If you put enough people under one roof, there are bound to be issues. Our firm is here to resolve them. So I think that's very apt for today's presentation. Oscar, welcome. It's so nice to have you here today.
Paula, thank you very much for that very thorough introduction there. I've been working with the People's Law School now, doing public presentations for quite a while now, about 3-4 years, if I recall. Obviously, before the pandemic, it was always at public libraries that we would be doing these type of presentations. Now it's in the virtual space here. That being said, as the list of attendees goes up, we can see why it's advantageous. We can, reach a whole number of people that we wouldn't necessarily be able to reach just, if it was a physical presentation. So I'm super happy to be here. I'm also happy to be here in the presence of Kate, who is leading the charge at the CRT there, and who essentially is really building something that is revolutionary, that is helping a lot of strata homeowners resolve issues that wouldn't necessarily otherwise have been resolved. So I think that's a tremendous job that they're doing at the CRT there.
Thank you so much, Oscar. And I love that you highlighted really how we're able to reach people so effectively through this medium, through the different mediums, the CRT's medium. So yeah, thank you. With that, we will turn to our questions, and we'll start with the first one, which is for you, Oscar. I'm thinking about buying a condo. I have a big dog and I play the drums. I'm told stratas have a lot of rules, and I'm scared I'll get into conflict and then be stuck as an owner. What should I do?
So that loaded question there, but I think the starting point that I would emphasize for everybody, all strata homeowners, including, of course, those on strata council who are also generally going to be owners there, is that when you live in a strata, you are not the master of your own domain. So, I think that's something that people think of, well, when I own a home, that I can generally do anything that I want with it, and they'll contrast, for example, being a residential tenant with being a strata homeowner, and they say, well, of course, I get to have a lot more freedoms as a homeowner than I would as a tenant. That may be true, but there's a logical limit to that. And the limit generally starts off with your strata corporation's bylaws. Now, again, kind of bringing back the CRT there into the mix. So I've been in the strata business for long enough that I predate the CRT, or at least my practice does. And I can tell you that when we used to go to a provincial court to small claims for bylaw enforcement matters, for example. And I remember early on, I was representing a strata corporation in small claims. There was an owner, self-represented, who was appearing before the judge, trying to explain to the judge why he did not, in fact, owe the fines that were being levied by the strata corporation. And the judge gave an explanation to that owner, which to this day I still kind of use this analogy, which is to say, your strata corporation's bylaws are essentially a contract that you enter into that is between yourself and the strata corporation. And you enter into that contract just by purchasing your strata lot. So you don't actually need to sign any sort of paper saying, I agree to this. It's simply by virtue of the fact that you've purchased into the strata development that you're now bound by the terms of this contract. And of course, as we'll get into a little bit later in today's presentation, but these bylaws can in fact be amended. So it's not a situation where it's the same set of bylaws that will govern your ownership throughout your time as an owner. Rather, it's a situation where this is kind of a living tree, so to speak. So it's something that can be amended over time, the ground rules. And from a strata corporation perspective, I do a lot of bylaw amendments for my strata clients, and I explain to them that your bylaws are also your tool belt to govern the strata corporation. So sometimes you have strata corporations with a little bit of outdated bylaws, and what you'll see is, in fact, I tell them, well, look, it's the same kind of idea when you're having a construction project. You can use an old set of tools to complete a project, or you can have a newer set of tools. Probably newer set of tools are going to be a little bit more efficient, and certainly you don't want to have a situation where you end up before the CRT, and the CRT tells you that your bylaws aren't enforceable. That being said, like I said, the bylaws are really the starting point, and owners can make complaints to the strata council in respect to a breach of the bylaws. And then the strata corporation has a duty to enforce these bylaws. So we're going to probably talk in today's presentation about how these bylaws are enforced, but I would generally note that there are three main enforcement mechanisms for bylaws. So one, fines. That seems to be the knee-jerk reaction of all strata councils, is to say, well, where in doubt, fine, fine, fine. Then there's also chargebacks. So chargebacks are a situation where the strata corporation has taken on an expense on the owner's behalf, or for example, to remedy an owner's contravention. And therefore, they will try to charge back the costs that they incurred to the owner. Again, the bylaws are going to be providing insight into whether you can institute a valid chargeback. And then, of course, there's simply legal action, which again ties us or brings us back to the CRT. In most egregious cases, you can, in fact, have yourself end up before the Civil Resolution Tribunal. So, in response to your question, if you have a big dog and you play drums, well, you better check your bylaws, your Strata bylaws, before you actually, or the bylaws of the Strata Corporation that you're going to be buying into before you purchase. You know, at the end of the day, the law, you know, says buyer beware, right? You want to make sure that, you know, you check out and understand what you're getting yourself into before your purchase, because your bylaws could have a pet prohibition, for example, right? I mean, it's rare, but there are strata corporations that, you know, prohibit pets from being kept on the strata lot. Or in other situations, you know, you may have a size restriction of a dog. So, you know, your dog may not meet the size restrictions. You want to check that. And if you know, if you're into loud music, well, you know, it's probably a little bit bad news, because you're going to have to be very careful of you know, to not contravene the nuisance provisions in your bylaws, and pretty much all standard set of bylaws will have some sort of nuisance provisions there. So.
That's really helpful, Oscar. And what I take from your answer then is really that anybody who buys in, as you pointed out, as this judge pointed out, is that you do enter into, you are bound by that contract. You are now bound by the terms of the bylaws. And from what you're telling me, the bylaws that are applicable in one strata may be different from those in another strata. And so it's worth doing that legwork to see, in particular, we're talking about a dog and we're talking about the noise potential, the potential for complaints. So really taking a look at that and deciding whether or not those are rules that you can live by.
That's correct. Yeah, absolutely.
Fabulous. Thank you so much, Oscar. Okay, this next question is for you. Here we have a situation where we've got trouble with a noisy neighbor and somebody who has suggested that they contact the CRT. So, Kate, what is the CRT and how does it work?
Yeah, so the CRT, as you said, it's Canada's first online tribunal for resolving disputes. So it was created to address and resolve disputes in a few areas. So right now we have jurisdiction over strata property disputes, small claims up to $5,000, motor vehicle injuries, and society and cooperative association disputes. So 4 areas. And the CRT was created by government at the time to address problems with access to justice for British Columbians that had been identified as a significant problem around access to justice, partly around delay in courts. There's been some Supreme Court of Canada decisions around delay for criminal matters, which means essentially courts have to prioritize those, because under the Charter of Rights, they have to proceed in a certain amount of time, which means that civil disputes like strata disputes sometimes get delayed, which is, you know, it's a problem for the parties. They can't move on, and then it can become very expensive to go to court. So that's why the CRT was created. It was created by legislation to increase access to justice. And the CRT's mandate is actually set out in the legislation that creates the CRT. So the Civil Resolution Tribunal Act is our governing and enabling legislation. And it says that our mandate is to provide dispute resolution services that are accessible, speedy, economical, informal, and flexible. So although the orders that the CRT makes at the end of a dispute resolution process are enforceable like a court order, our processes are not identical to court. They are more flexible, they are somewhat more informal, and they are primarily online. We have ways of accommodating people who just aren't computer people, but for the most part, except for about 2% of cases, everything is done online through online portals, some phone calls, some email, but also we have a really comprehensive online portal that I'll talk about. And the CRT, as part of our mandate, we encourage a collaborative problem-solving approach to dispute resolution, unlike a traditional courtroom model, which just is around getting a decision. So we have sort of different stages in our process. So our goal around offering timely access to justice, is to offer legal information, self-help tools, and then dispute resolution services. So just a little bit of history. We began taking cases at the CRT in July 2016, and the first area we started taking cases in was strata property disputes. And then about a year later in 2017, we started taking small claims disputes. So since then, we've resolved, as you said, somewhere just south of 4,000 strata property disputes. More than half of those are resolved before getting to a final adjudication. So I'll talk about we have kind of a negotiation and a mediation phase. So at least half of disputes get resolved at that stage. So that's sort of the overarching answer to the question, what is the CRT? And who can be involved in a strata property dispute at the CRT? Well, owners of strata lots, or strata lots can be apartments, townhouses, they can just be a plot of land. So strata lot owners, tenants of a strata lot, or strata corporations, or sections of a strata corporation, which is essentially if you have a residential section or a commercial section. Those are the people who can be parties, or bodies that can be parties. So if you have a dispute, for example, against a contractor who did work in a strata building, probably it might be a small claims dispute, but it wouldn't be a strata property dispute that would go to the CRT. So owners, tenants, strata corporations basically are the parties. If you have a concern with a landlord and you're a tenant, likely your dispute would probably go to the residential tenancy branch, but there is information on our website about how to figure that out, and I'll sort of circle back to that. A couple of things. One thing is that the Strata Property Act governs stratas in British Columbia. It's a very detailed act. It says, among other things, that before you can file a dispute at the CRT, if you're an owner or a tenant, you have to request a hearing with the Strata Council. And the reason for that is to encourage dispute resolution. So we can't get there and the Strata Corporation say, we didn't know about this, we could have responded to it. Anyway, so it's just sort of an initial step. So that's one thing to consider. And actually on our website, there's some template letters that you can use if you want to request a Strata Council hearing, or you can just email. It's easy to do. So in terms of the CRT's process, there's essentially 5 phases, the last being getting a decision. So the first is through our website. It's what we call the Solution Explorer, which is a self-help legal tool. I'll talk a bit more about that. It essentially provides information, kind of if you've ever done a tax return, an income tax return through tax software, it asks you these sort of questionnaire questions, and it guides you through the process of filing your income tax return. It's a little bit like that in terms of guiding you through it'll ask you, are you an owner? Are you a tenant? Are you on the Strata Council? What's your dispute about? And sort of narrowing the issues so and then there's some pop-ups that come up with legal information or template letters, that kind of thing. So you can go through that. The next stage is to apply, which is done online typically. The third phase is a negotiation phase, which is essentially, it's pretty short. It's essentially like a Facebook Messenger chat, which it basically encourages parties to exchange offers. Sometimes parties don't want to do that. Sometimes they do. It actually has a pretty high settlement rate. So I think around 25% of disputes actually settle at that phase. And it's basically completely online. There's not really a person involved from the CRT. It's just a technology step. Just takes a few days. The next step is a facilitated process we have many case managers. They're mostly experienced mediators or have some kind of training around legal, either law or specifically dispute resolution training. And they do a couple of things. One is they help the parties kind of clarify what it is they want. They have a mediation process, which is mandatory. And if the dispute doesn't resolve in the mediation process, they will do some case management, getting it ready to go to an adjudicator for a decision. And then the final stage is, which, as I say, most disputes don't get there, or perhaps only about half, is to be assigned to a tribunal member for a decision. And there's a process for uploading evidence, usually in the form of documents, sometimes recordings, submissions, which are done in writing, and then we publish written decisions. And all our tribunal members are lawyers located around the province, most of whom most of the current decision makers work for the CRT full-time right now. We also have part-time decision makers as well who have legal practices and do part-time work for the CRT. So that in a nutshell is what the CRT is. And then to circle back to the question about the noisy neighbor, yes, we get lots of disputes at the CRT about noisy neighbors. I'll talk a bit more about that later in this presentation, but certainly that would be something the CRT would have authority to decide, and we frequently do get those kinds of disputes.
Fabulous. So. Thank you so much, Kate. I mean, it's so great for you to lay out that process and to let people know that, you know, before starting the process, that you would want to request a meeting with your strata, you'd want to follow certain steps, and that it's not that you jump straight into a hearing, that there are multiple steps along the way that allow you to approach it one step at a time and see if you can resolve it at an earlier stage. That's really helpful information. Thank you.
Yeah.
This next question is for you, Oscar. My upstairs neighbor submits a biweekly calendar to our strata with complaints about noise, and then those complaints are sent to me. Can ongoing complaints be considered a nuisance?
It's a very good question there. I had $1 for every such complaint that I hear of. I'd be better off. I mean, you know, I think as a starting point, I would say that, you know, strata councils and property managers, and, you know, if there are any, and I assume, well, apparently there are a few who are joining us who are on their strata council and who may be in the property management field, they absolutely hate these type of complaints. They hate these scenarios where essentially they have to mediate between, you know, two owners regarding a bylaw infraction. Yet the strata, as I mentioned, has the obligation to enforce its bylaws. So, you know, the strata corporation doesn't really have much of a choice in this matter, even if they would prefer to sweep this matter under the rug. In terms of nuisance complaints, the law will always look at these type of complaints from the point of view of a reasonable person, which is to say, if you happen to be particularly sensitive to either noise or smoke, assuming there isn't already a smoking prohibition in place in your strata, then, you know, really it's what a reasonable person, whether a reasonable person would be bothered by such activity. So, you know, the best example I can think of is in my own family, where my father, you know, will take a family trip. You know, he'll check himself into a hotel room, and the first thing he does is complain about the noise. And he's particularly sensitive about noise there. But, you know, the law doesn't really view noise complaints so much from the perspective of the individual who's complaining as it is from, you know, if a reasonable person, if the average person were to be put into the same scenario, whether they would in fact be bothered by the noise. Now, sometimes these complaints are legitimate, and other times these complaints are completely unfounded, or sometimes even retaliatory. It's really up to the strata corporation to investigate, first of all, these complaints, right? So I think it's really a dual approach. It's not just a situation where the strata gets a complaint and then, you know, automatically a fine is assessed. Rather, they have to investigate whether there, you know, is a substance for these complaints. And then there's a procedure under the Strata Property Act where they can in fact decide whether there is a bylaw infraction. It'll be tough to qualify an abuse of the bylaw complaint process itself as a bylaw breach, but more often strata councils will start paying less attention to complainants that have been found in the past to make unfounded complaints. And in terms of the bylaw that would be applicable for maybe applicable for this type of situation, well, the standard. So I'll preface this by saying that your strata's bylaws may be completely different than the standard bylaws at the Strata Property Act, right? More often than not, what you'll have happen is the larger strata corporations will have a custom set of bylaws that will often include some of the contents of this standard bylaws appearing in the Strata Property Act. So if you Google Strata Property Act, you scroll all the way down to the bottom of the page, you'll see that's where you'll see the standard schedule of bylaws. And in that schedule, you'll find a bylaw 3, that says an owner, tenant, or occupant or visitor must not use a strata lot, the common property or common assets in a way that, among other things, causes a nuisance or a hazard to another person. So essentially that's, when you're looking at interpreting those bylaws, I mean, most stratas, even the ones with custom bylaws, will reproduce this bylaw. That seems to be a common thing to have in the bylaws, is this nuisance bylaw. And so when you're looking at this situation, you're looking at applying, among other possible bylaws, this bylaw to determine whether there was a breach.
Excellent. Thank you so much, Oscar.
Absolutely.
Okay, this next question is for you. My neighbor keeps smoking even though the bylaws say that it's not allowed. The strata knows and isn't doing anything about it. Would this be the kind of situation I could bring to the CRT?
Yeah, so the short answer is yes. We have decided a number of cases about smoking, both cigarettes and marijuana, smoke, smell. It's similar to noise. It can be considered a nuisance, and every strata basically by default has a bylaw about nuisance. And the CRT has jurisdiction to interpret and apply bylaws. So that's the short answer. The long answer is I'm going to talk a little bit about what the CRT has jurisdiction to decide. Jurisdiction just means authority. So unlike the BC Supreme Court, the Supreme Court has something called inherent jurisdiction. It basically comes from the Constitution, can decide any issue that comes before it. The CRT, it's part of a collection of administrative tribunals in British Columbia. There's about 40, and they have similar powers to a court, as I've said, but their authority or their jurisdiction is only what's set out in their enabling legislation. So in our case, it's the Civil Resolution Tribunal Act. And under the Civil Resolution Tribunal Act, or the CRTA, we have a fairly broad jurisdiction around strata property claims. So essentially, the CRT has authority to decide most claims that arise under the Strata Property Act, and that's the language in the legislation. So that can include interpretation of the Strata Property Act, the Strata Property Regulation, Strata Bylaws, and Strata Rules, common property and common assets of a strata, use or enjoyment of a strata lot, so an apartment, townhouse, whatever, money owing under the Strata Property Act or bylaws, including bylaw fines, or an action, threatened action, or decision by strata in relation to an owner or tenant. And then some more complicated stuff around voting that I won't get into. So that's a lot of things. So what does that mean? Some of the most common cases we see a lot around damage related to water leaks. That's related to insurance, which is kind of a big issue in strata corporations right now. We see lots of cases around nuisance, so noise, secondhand smoke, pet noise, pests like rodents or bugs. We see a few of those lately. Maintenance and repairs. So usually, does the strata have to fix something, like say a roof or a fence, and also who has to pay to fix various things? Bylaw fines and enforcement, financial management. So usually how the strata is spending its money and how it's recording its finances, or, budgets. There's rules around in the Strata Property Act around budgets and getting approval for budgets and keeping financial statements. Governance. So that's basically holding meetings and voting. Document requests, rentals, short-term accommodations like Airbnb. We got disputes about that. Pets, So those are some of the more common cases we get, and we have authority to decide those. Some of the things we don't have jurisdiction to decide include defamation, so that's libel and slander, conflict of interest by strata council members, that has to go to BC Supreme Court. We get a lot of potential claims around bad faith or wrongdoing by a strata council member. Generally, we don't have jurisdiction to decide that unless the applicant is the strata corporation, which rarely happens. Removal of liens, appointment of an administrator for the strata, wind up of a strata. We don't have jurisdiction. That all has to go to Supreme Court. And then there's a few other things that are all set out in section 122 of the CRTA, if anyone's interested. So to go back to the question, which is about smoking. Yeah, so cases like about smoking are similar to noise nuisance. They're governed by the bylaws that Oscar's talked about. CRT definitely has authority to interpret and apply bylaws. So we have done that in smoking cases. Generally, what bylaws say almost always about nuisance, which can include smoke, is that an occupant can't create a nuisance that unreasonably interferes with others' use and enjoyment of their strata lot or the common property. And so the question is in many cases, what is reasonable? And there's a lot of case law on that, but essentially that would be the question. And as Oscar says, it's the strata's responsibility to enforce its bylaws. So if you've complained to the strata council and feel they haven't sufficiently responded, you could potentially file a claim, and the CRT would have authority to resolve that.
Fabulous. Thank you so much, Kate. I really appreciate how you took us through all the different categories of claims that you would be able to consider, and also outlining some of the claims that you would not be able to consider. So that's a really useful, and we can provide links to the legislation that you mentioned for anybody who's interested, and that will appear with the recording of today's webinar. Thank you.
Yeah. And the CRT website also is great.
And the CRT, of course. Thank you. Oscar, this next question is for you. With lots of smokers and shared ventilation among units, odor from smoke is a problem in my building. At the last AGM, a bylaw to prohibit smoking was voted down. What can I do?
Right. So this is perfect because it kind of carries forth or forward our discussion about nuisance and the nuisance bylaw provision that I read out there. So, as a starting point, I think, even if you don't have a smoking prohibition bylaw, you can still assess any sort of issue like this on the basis of the general nuisance provision, nuisance bylaw. And so, for better or worse, in situations like this where, somebody has an issue that, and there is no smoking prohibition within the bylaws, then, the default or fallback position is, well, you're going to try to assess to see whether any other bylaws are being breached here and whether you can characterize this as a bylaw breach. Of course, as is often the issue, we're talking here about competing rights. So I think that's something that is a very common theme, and I'm sure that Kate will agree that you see a lot of this at the CRT, where it's not just a black and white issue. It's not just a matter of, oh well, was there a bylaw infraction or not, but rather you're talking about trying to balance the rights of certain owners against other owners, right? And so the question here is really kind of exactly that, which is that the right to consume cannabis for medical reasons versus the right to quiet enjoyment of your strata lot. And without a smoking prohibition, as I mentioned, this would be harder to fight. And so you would have to prove not only that the specific owners in questions are smoking, but also which can be hard because you have to kind of trace it back to one unit there, but also that it creates a nuisance. So when you're relying on the nuisance provisions, it's a little bit of a harder case to make when it comes to proving a bylaw infraction. In this case, I would probably recommend a number of different steps. So first of all, speak with your strata council. So Kate mentioned that a integral part of the CRT process is having owners communicate with the strata council. I would say before you even file a CRT complaint, make sure that there is or a level of communication, because I lost track of the number of times that an owner complains, contacts a lawyer like myself about a matter, and then we find out that as soon as we start opening up the lines of communication with the strata, the problem is resolved, and you don't actually have to go to the extent of even filing a CRT complaint. So speak with your strata in this case. See if there's a chance that the strata would be willing to convene a further special general meeting, SGM, to reconsider the failed vote on the smoking prohibition. Then, of course, if the strata council doesn't want to play ball, you do have the option of getting a petition or starting a petition under Section 43 of the Act to call a special general meeting to reconsider the smoking prohibition. We've mentioned amending bylaws. I think it's important to recognize that the bylaw amendment process requires a 3/4 vote by the owners at a general meeting. So whether it's a special general meeting or an AGM, an annual general meeting, it's in residential context. So again, it's a little bit different for commercial stratas, or mixed use stratas. But for residential stratas, you're looking at a 3/4 vote, which is a high threshold to achieve, right? That's often why strata bylaw amendments fail, is because you're just short of that 75% threshold of achieving the vote there. And then if the smoking prohibition bylaw eventually does pass, then the strata council will be called upon to decide whether, quote unquote, reasonable accommodation should be made for elders using cannabis for medical purposes. So there, I've just opened up a whole new can of worms there, because now we're talking about human rights, and I can probably go on for an hour or 2 hours just about human rights issues here. We're not going to do that, but essentially, I will make mention of the fact that the Strata Corporation, when faced with a potential human rights issue, does have to consider whether, well, first of all, whether there was a breach by the Strata Corporation, and second of all, if there was a breach, then whether reasonable accommodation can be provided to the owners whose rights have been breached. So in this case, if you have a situation where you have a smoking prohibition that has been passed, and then you have a cannabis smoking prohibition, and then you have somebody who says, well, you know what, I have a medical condition that may require reasonable accommodation by the strata, then the strata has to assess what steps can be taken to reasonably accommodate that owner if their duty to reasonably accommodate is triggered. And really what it is that I think it's interesting to point out and to tie back to the CRT. And Kate, you can correct me if I'm mistaken on this, but I believe that one of the first decisions of the CRT was actually, I think it was a default decision, but it related to cannabis smoking. And I recall that it found essentially that reasonable accommodation in that case, which is not necessarily the case in all circumstances, but in that specific case, reasonable accommodation for the owner was essentially saying that the owner can ingest cannabis products, and that they could get their medical condition accommodated by simply ingesting and eating cannabis products as opposed to smoking in the building. So
fabulous. Thank you so much, Oscar. It's clearly a question that raises a number of issues. So there are a number of options, but also, as you mentioned, this human rights consideration that might be brought into play. We have 3 more prepared questions to go, and Kate and Oscar, I'm going to ask that we answer them relatively briefly, just so that we can leave some time for live Q&A. So with this next one, I'll turn this one over to you, Kate. I'm thinking about starting a claim with a CRT, but I don't know if I want to go all the way to a hearing. What other options do I have, and do I need a lawyer?
Yeah, that's a good question. So you have lots of options. The first of which I would suggest, actually, for anyone who just has a general strata question, the Condominium Homeowners Association, if you just Google it, it's CHOA, C-H-O-A, has a great website, and they publish bulletins that are basically, they're actually published in the newspaper periodically, and they're just questions that owners and strata councils have, and they're great. It's an excellent source of legal information, and you can actually join and ask some questions. So they're a great resource. The second resource is the CRT website. As I've said, has this Solution Explorer, which is free. It's online. Its goal is to provide free, confidential legal information, self-help. A ton of resources went into it, both government funding, but also just many volunteer hours from strata lawyers, CHOA, other people with a lot of experience in this area to create this content. And as I say, you can use it. It's sort of a decision tree format, so it kind of funnels you in different directions. It's confidential until you decide to give your name and maybe start an application, but prior to that, it's all confidential. It's all written in plain language. Everything is aimed at a grade 6 reading level. We're actually in the process of posting videos with subtitles. That's kind of a project that's ongoing. So that without getting into too much more detail, the Solution Explorer is a great resource. Again, it has template letters you can use to ask for certain things. You just plug in, names and addresses. So that's useful. And so that's on the CRT website. The other thing on the CRT website is our decisions database. So all of our final decisions are published on the internet. You can search by topic. The database is really helpful. And CRT decisions, they're not actually binding precedents, unlike a court decision. But one of the goals of all tribunals is to have decisions that are predictable and is consistent and therefore predictable. So you can definitely get a sense of how prior similar cases have been decided. And for the most part, it's likely your case would be the first time that issue has ever been raised at the CRT. It's possible, but it's unlikely. Usually there's other cases that you can find and see what happened with those. And then even after you file an application with the CRT, a hearing is, as I said, not the first step. There's a negotiation phase, a mediation phase, a case management phase, and the CRT case managers can help with all of that. So the second part of the question was whether you need a lawyer for a CRT dispute. The short answer is no. And in fact, under the CRTA, Section 20 sets a general rule that parties must represent themselves in a CRT proceeding, except for a motor vehicle injury proceeding. So basically, you can consult a lawyer. You have to represent yourself unless you get permission to do otherwise, and permission would be granted where it's in the interests of justice and fairness. And there's some cases that we've published in our database that talk about when that might be. But the short answer is no, you don't need a lawyer. And in fact, generally you have to represent yourself. And if you have a problem around capacity, around English, or if, for example, if you're a minor, obviously there's exceptions there. So.
Fabulous. Thanks so much, Kate. I appreciate those resources that you've pointed out. Just a quick question about hearings. You mentioned earlier that it involves written submissions. Is there an oral advocacy, or I guess an oral component to it, or is it all through written submissions?
Generally, it's all written submissions. We can do oral hearings. We would do video conference or perhaps telephone conference, but typically it's all written submissions.
Super. Thank you so much, Kate. So Oscar, this next one is for you. If you wanted to put a new flooring into your condo, do you need a permit for that?
Well, absolutely. The short answer is, you do need to seek consent of your strata council for, essentially, I would suggest that as a rule of thumb, you should say any sort of alteration, it's better to run by the strata council or the strata corporation rather than trying to guess what you may need consent for and what you wouldn't. The defining point, though, being that it has to be, or it can be a change, it's an alteration. So if you're just, replacing a light bulb, you're not going to need to, contact your strata council about that. That being said, though, if there is an alteration to your strata lot, such as a change in flooring, if again, we mentioned the standard schedule of bylaws there. And there are two relevant standard bylaws, one that pertains to alterations to a strata lot, and the other that pertains to alterations to common property. The key difference between the two, so both require consent on the part of the Strata Corporation or from the Strata Corporation. The difference, though, fundamentally is that when it comes to alterations to your strata lot, the standard set of bylaws would suggest that the Strata Corporation cannot unreasonably refuse consent. And when it comes to flooring, there may be separate bylaws. In fact, there are often separate bylaws that deal specifically with flooring within your bylaws. So if your Strata Corporation is one of those Strata Corporations that has a custom set of bylaws, then you should review those bylaws carefully, because oftentimes you will have a specific bylaw that will address flooring, that will give further details about what type of, for example, underlay that you need, and all of these bylaws are really meant to address the ongoing theme of the day, which is nuisance, which is to say that you want to make sure that you're able to live in your strata lot without compromising your neighbor's right to quiet enjoyment. One very quick thing that I wanted to pick up on, which is following what Kate was suggesting about the CRT and about lawyers, and this is rather self-serving there, but I'll do this on the part of the entire Strata property bar. So, and even for just to benefit homeowners. So Kate was absolutely correct in noting that there is a general rule of self-representation at the CRT. Functionally, what that means, though, because if you read the Strata Property Act, let's put it this way, it's not very easy to understand. That's why you're so reliant on resources such as CHOA, such as another great resource is Mike Mangan's Condo Manual, which is a little bit, it's a few years old now, so it's going to be in the process of being reworked, but it's still a great reference there. And so at the end of the day, oftentimes homeowners will still benefit from some sort of legal advice. And the CRT does allow, through its process, the use of what it terms as helpers, which is to say people who are in the background. So you may be still self-representing, you may still be communicating with the CRT directly. However, you can retain a strata lawyer or just about anybody. It could even be a helper, could be your friend who may be a little bit more cognizant about what the strata rules are. And they would be able to assist you through the CRT process. So, a lot of what our firm does is we're kind of in the background. We let our clients communicate with the CRT directly, but we are able to assist them with the drafting of the application, with the drafting of their arguments, with the collection of their evidence. Those are all examples of situations where a lawyer can in fact assist you with your CRT claim. So I think that's important to just point out there.
Super. Thank you so much, Oscar. Kate, this is our last question. We are running short on time for the live Q&A. So I'll ask you the question, and then I will unshare my screen and start looking at the live questions that are coming in. Kate, the question is, my neighbors won't stop making noise and my strata isn't doing anything to stop it. If I went through the CRT process, what types of remedies could they order? And could they order remedies against both my neighbor and the strata?
Yeah, so the types of remedies the CRT can order is set out in the Civil Resolution Tribunal Act. So basically, we can order a party to do something. We can order a party to stop doing something. So those are basically called injunctive orders. So do something, stop doing something, or pay money. We can order a party to pay money, either to fix something or as damages, like as compensation for something that's happened. So, and then finally, we can make an order that's necessary to prevent or remedy a significantly unfair action, decision, or exercise of voting rights by the strata or someone who controls the majority of votes in the strata. So that's a more broad power. So the kinds of things we can order, for example, in a noise dispute would be, we could order a party to stop making noise. Now, if the bylaw already sets out noise restrictions, that might not be super meaningful if the person's been warned about that and has ignored them. We can order damages, although there's some issues around that. that I won't get into here about subject to our small claims limit of $5,000. We can order the strata to take steps to do something. So for example, to investigate, which might involve pulling up some flooring to see what the flooring's made of, or do noise testing. So it's pretty broad. And in terms of who we can order remedies against, we can order remedies against parties. So if someone's not a part, so usually a respondent. So in that case, when you're applying, you would need to add both the strata corporation and the neighbor as respondents to the dispute. And you can amend that later, but generally that's what would have to happen. We're not going to make an order against someone who's not part of the dispute, because it wouldn't be fair, because they never had a chance to defend themselves. So that's sort of it in a nutshell.
Super. Thank you so much, Kate. And I'm just going to unshare my screen so I can see the live Q&A. And while I do that, I'll just follow up on that question with you, Kate. This is one that came in through one of our viewers before the webinar. When a complaint is brought before the Civil Resolution Tribunal, does the tribunal uphold strata bylaws that have been voted on by the majority of its owners?
Yes. So we are required to follow strata bylaws to impose them. They're binding on everyone. So a bylaw, for it to be valid and enforceable, has to be approved by a 3/4 vote of the owners at an annual or special general meeting, and it has to be filed at the land title office. If it's not filed, it's not enforceable. So.
Fabulous, thank you. So here's a live question. It has 7 votes. What are the resident rights regarding video surveillance? For example, can a neighboring townhouse have cameras that look into their neighbor's yard or front door? So Oscar, this looks like a question for you.
Yeah, I mean, and it's funny because this is a topic of conversation that I'm actually in the midst of, or in the process of preparing an article about. It's something that started off as a conversation between the Strata Council and myself. In short, whether it's video surveillance that is being put in place on common property by the Strata Corporation, in which case then you have to be very cognizant of the privacy commissioner's suggestions about the placement of video surveillance. The privacy commissioner, in fact, I think might be helpful. Maybe at the end of this question, I can probably find that link there, but it actually has a whole set of guidelines for strata corporations in respect to privacy matters. So I don't think we're going to have time to go through all of that today, or even much of that. But the bottom line is that the strata corporations are subject to privacy legislation. If you're putting in video surveillance in any way, shape, or form, you have to have a bylaw that authorizes that. Now, again, the topic of conversation, it's shifting from originally it was just the Strata Corporation who was going to put in security cameras for the sake of making sure that the safety of all residents, for the sake of ensuring the safety of all residents. And then what we're seeing now is, well, how do we apply these same issues where you have, for example, in a townhome complex, you could have owners who are putting in those Ring doorbell cameras, right? And how do you grapple with that? And so I actually had to draft up a custom bylaw for a Strata Corporation who was going to vote on whether they were going to allow these type of cameras to be installed by homeowners. But again, I think the fundamental starting point is, you have to have a bylaw that authorizes this. And number 2, you have to always be cognizant of the Strata Corporation's obligations under provincial privacy legislation. You don't want to be in breach of those.
Super. Thank you so much, Oscar. Kate, here's a question that I think would be really helpful for our guests. What steps is a CRT taking to assist people who don't have easy access to computers?
Yeah, so that comes up about 2% of the time, which we thought initially it would be more. It actually isn't. So if you can do things usually by phone and regular postal mail. So if you contact the CRT, you can ask. You can get help through a representative, for one thing. You can ask for permission to do it that way. Alternatively, you can get permission. You can file an application through Service BC locations physically, and then you can proceed using the telephone and postal mail. It's a little slower, but we do permit it.
Fabulous. Thank you so much. So Oscar, this is a question. I attended a meeting and it was over a sensitive topic. The lot number can be easily linked to the unit number by the AGM maintenance increases. I'm afraid I can be targeted now. So this was actually another, believe this question was submitted to us before the event. And is there anything that would say that you shouldn't have that information in the Strata minutes?
Well, so I mean, certainly this again, it's a privacy issue. So the Strata Property Act is going to contain absolutely no provisions that will specifically address this. In fact, this is even I would say even if you look at the PIPA, the Personal Information Protection Act in British Columbia, you're going to not find a specific answer to this, except where you're going to find the answer is in the Privacy Commissioner's guidelines. So I see in the chat there that now this is the second time that we've posted the link there. And so if you look at those guidelines, the Privacy Commissioner, what their position has been in respect to Strata Council meeting minutes is, and again, this falls back on this issue of what is reasonable, right? I think Kate was the one who was mentioning before, it's very inherently subjective what is reasonable. What may be reasonable to myself may not be reasonable to Paula or to Kate, right? So at the end of the day, though, because we need to follow what the Privacy Commissioner is going to suggest is reasonable, then we need to refer to the guidelines. And in respect to publishing Strata meeting minutes, while owners are definitely entitled to know what is happening, what the business is that is happening with the Strata Corporation, certainly the Strata Corporation has an obligation to balance the needs for privacy with the need to inform the owners of what's going on. And so the Privacy Commissioner has said that the Strata Corporation should be publishing only what is reasonably necessary in terms of to inform owners, which is to say that you're not going to be publishing names of owners in Strata meeting minutes. It's debatable whether you would need to reasonably include a Strata lot number.
Okay, thank you so much, Oscar. That's really helpful information. Kate, thank you so much. Do you have any parting words that you'd like to share with our guests today?
No, other than just to suggest that people do check out the CRT's website. If you just Google it, there's a lot of resources, and I think it's pretty useful for people.
Fabulous. Thank you so much, Kate. It's been so great hearing from you and hearing the perspective of the CRT and all of the tools that are available to people out there who have concerns or problems, that they now have an additional resource that they can go to. So it's wonderful. Thank you.
Yeah, thanks for having me.
Thank you. And Oscar, thank you so much for being here today. It's been so great having your answers to these questions. And before we sign off, is there anything that you would like to share with our guests today?
Well, I'll just echo that there are many resources. So certainly, Civil Resolution Tribunal's website, if you're if you're really curious about how these strata property issues get resolved, then they do publish, as Kate mentioned, all the decisions on their website. It's certainly informative to review how those decisions were made. And then, of course, as I can see that you posted on the additional resources, housingguide.ca, that is my own website where I post numerous different resources for strata homeowners and for residential landlords. So it's all free legal information, free tidbits of advice that we publish as a firm.
Thank you again, Kate and Oscar. Have a wonderful afternoon, and thank you everybody for being here today.